Hello, everybody, and welcome to History Bite number 99, dated October 31st, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Third Amendment to the United States Constitution. The Third Amendment to the Constitution is one that you very rarely hear about, either in general conversation or from politicians or lawyers or anybody else, as a matter of fact. And that's likely due to the very limited scope of what the amendment actually does. The Third Amendment to the Constitution specifically prohibits U.S. Army soldiers from being quartered in the homes of Americans in a time of peace without the consent of the homeowners. And it also only allows the practice in general in time of war in a manner to be prescribed by law. Okay? So the direct text of the Third Amendment reads as follows. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. All right? So it's pretty straightforward and direct in what it allows and what it disallows. Okay, so under no circumstance can U.S. Army soldiers be stationed in private homes in peacetime without the consent of the owner. And it can only be done in wartime in a manner to be prescribed by law, so not arbitrarily. All right, so that's what the Third Amendment does in a nutshell. All right, the Third Amendment, okay, is a reflection of American hostility to what was a very common British practice before and during the American Revolution. Okay, prior to the American Revolution, during the 7 Years' War, and even closer to the point of revolution with the Quartering Act of 1774, okay, which was one of the intolerable acts, if you recall. With that act, American colonists were often required to house British soldiers in their private residences. And that meant providing them with food, drink, perhaps leisure, and colonists weren't given a choice in this matter. All right. This was forced upon them, even though it was prescribed by law. All right. And this was in both peacetime and in wartime. All right. The Quartering Act of 1774, like I said, was one of the infamous intolerable acts, which collectively were major catalysts for the American Revolutionary War kicking off the following year in April of 1775. Okay, so American colonists greatly despised this practice of having to house British soldiers, okay, without their consent. It wasn't right, and they had to take care of these British soldiers on their own dime. Okay, which further adds insult to injury. All right. So in the new United States, under our Constitution, it is no surprise that this provision would make it into one of James Madison's original 12 proposed amendments to the Constitution itself, as this, of course, is not in the original Constitution's language. Okay, it came in the form of amendment. All right. And Americans were very, very passionate about this, okay, so that our new federal government, all right, would not be able to, in peacetime, force the people to house American soldiers without their consent, all right? And it could only be done in wartime in a manner to be prescribed by law, thus an act of Congress, all right? So it was very regulated, all right? Peacetime, totally off the table without the consent of the homeowner. All right, in wartime, it could only be done in a manner prescribed by law. Very direct, very to the point. All right, not much debate over what this means, in my humble opinion. Okay, and with that said, due to the, very limited amount of wars that have been fought on American soil, though, the U.S. government has never needed to house U.S. Army soldiers in private residences, whether in peacetime or wartime, okay? And because of that, there have been very few opportunities to invoke the protection of the Third Amendment for anything, all right, though it has been invoked. It has never been the primary basis for a U.S. Supreme Court decision, though it has been cited in U.S. Supreme Court decisions as a supporting authority in certain cases. A couple of examples include the Supreme Court's 1952 decision in Youngstown Sheet and Tube Co. versus Sawyer. Justice Robert Jackson, who authored the majority opinion, cited the Third Amendment as a check on executive power during wartime with respect to the U.S. Army and the executive's power over the U.S. Army. All right. And it was also cited in Justice William O. Douglas's 1965 Griswold versus Connecticut opinion, where the Third Amendment's emphasis on the sacred nature of the house and privacy within one's own home, and to the exclusion of unwarranted governmental invasion, all right, was emphasized, all right? So the Third Amendment was used in that case, all right, to emphasize the privacy of the home and to protect it from unwarranted governmental invasion, all right? So the Third Amendment has made appearances in Supreme Court decisions, though, like I said, it has never been the primary basis of a U.S. Supreme Court decision. Arguably, the farthest that the Third Amendment has ever gone, all right, was in 1982 in a case known as Engblom versus Carey, which was a decision of the United States Court of Appeals for the Second Circuit, which covers the states of New York, Vermont, and Connecticut. Okay, and based on an action by the state of New York, all right, the Second Circuit Court of Appeals incorporated the Third Amendment to the states in the Second Circuit. Like I said, New York, Vermont, and Connecticut. All right. I'm not going to get into the details of Engblom versus Carey. If you want to look that case up, feel free. It is a case from the U.S. Court of Appeals from the Second Circuit. From that decision, where the decision of the state of New York was ruled to be unconstitutional, all right, the Second Circuit, like I said, incorporated the Third Amendment and made it applicable to the states in that circuit, all right? Because this was a sole Court of Appeals decision that was not reviewed by the Supreme Court of the United States. Its effect was very limited, in fact, only, of course, to the states of the Second Circuit, all right? So as far as New York, Vermont, and Connecticut are concerned, the Third Amendment to the U.S. Constitution is fully applicable to them and incorporated to those states via the 14th Amendment's Due Process Clause. To date, the Third Amendment otherwise is not applicable to the actions of any other U.S. states except those in the Second Circuit. Again, New York, Vermont, and Connecticut. All right. It's a unique position that no other amendment has ever been in. Okay, the Supreme Court incorporates the amendments, of course, to all the states, but since they did not take this case from the Second Circuit to review it and apply the Third Amendment to all the states, the Third Amendment does not bind the actions of any states outside the Second Circuit. So it's a very unique circumstance. All right. So as far as we here in Maryland are concerned, the Third Amendment does not bind the actions of the state of Maryland, only the states in the Second Circuit. All right. But the Third Amendment has made other appearances. Most recently, all right, an individual filed a case in the U.S. District Court for the District of Nevada with respect to police action. All right. They were asserting that the police were restrained by the language of the Third Amendment. And the U.S. District Court did not accept such an assertion, okay? In fact, it held that, despite the appearance and equipment of soldiers, police officers are police officers, okay? Not soldiers, okay? So that case did not go well for that plaintiff. All right, Mr. Mitchell. The case is Mitchell versus City of Henderson. All right, and it is from the United States District Court for the District of Nevada. All right, so Third Amendment claims, obviously, unless they are, based and tangibly tied to actions of the United States Armed Forces, the National Guard, all right, a Third Amendment claim is not likely to prevail in federal court, okay, which is why there were other claims also under the Third Amendment in history, but none of them bore any fruit. Only the case of Ingblom versus Carey in 1982, all right, has actually got the Third Amendment any real notice as a significant piece of real case law, all right? And so that is where the Third Amendment stands to this day. It is not incorporated to any states outside of those in the Second Circuit, and is not likely to be incorporated to the rest of the states anytime soon, as it is not an amendment whose protections essentially are viewed as impending or necessary for the rest of the country. All right, as no state has done anything which would seriously require or suggest that the people need to invoke its protections. All right, so that's the Third Amendment to the U.S. Constitution, folks. Quite simply, before I let you go, I'll read it one more time. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. All right, so no U.S. Army soldiers can be forcibly required to be quartered in your house without your express permission in peacetime, and they can only be quartered in your house in wartime in a manner prescribed by law, thus by Congress. Okay, so that's the Third Amendment to the U.S. Constitution, and for now, that's as far as it's going. So I hope you learned a thing or two from this history bite. If you have any questions or controversies, leave them down below and I'll be happy to answer them. If you have not subscribed to my channel, it would be most appreciated if you did. Thanks so much for listening. I appreciate all of you. Okay, take care. Stay safe out there. And I'll talk to you at the next history bite. Peace.